I could easily teach a university course on intellectual property risk management. So be advised that everything that I'm presenting here today is an 80-20 view. There are always exceptions, nuances, details that we can't possibly cover in an hour. And you guys would be dropping off the presentation like flies by intended to do that. Although the title of the presentation mentions IP, I am going to use patents as the platform for delivering this content. I do believe that at least 80%, probably closer to 90% of what I'm going to go over today can be applied to other kinds of intellectual property, whether it's trade secrets, copyrights, software code, and the like. But I just want you to be aware. Let's start with establishing a basic vocabulary. What's risk management? My view of risk management is that it is a process by which we are trying to limit the uncertainty or the variability of outcomes over time. Now, when most of us think about risk management, we think about managing negative outcomes. Sorry. If you're an economist or if you're a person with a grounding or education, theoretical finance, risk means a little bit different. Anything that's different from what you expect, even things that happen better than you expect, are considered risk. We're not going to get into that esoteric discussion, but I put it out there so that we have a full understanding of what risk could potentially mean. And so what we're trying to do with risk management, and what I think most of you are tuning in for, is you want to know how you can prevent things from going wrong in the first place, or at least reduce the likelihood. And for example, to prevent an accident in a car, you manage risk by potentially taking driving lessons or making sure that your brakes are well maintained, or getting your vision checked, whatever it is, or don't drink alcohol before you drive, right? Those are methods of risk management to prevent an accident from taking place in the first place. And then type of risk management is in the event that you do find yourself in an auto accident, that the result is as benign as possible, right? In an auto accident, at one extreme, it could be a fender bender, maybe it's bumper to bumper, there's actually no damage, and so you just ticked. But there's no damage to the car, there's no damage to people. And of course, the other end of the spectrum, there's the catastrophic event of a loss of the vehicle, severe injury, or loss of life. And automobile manufacturers seek to help you manage risk by instituting seatbelt and lane change warnings, backup cameras, front and side impact airbags, and so forth, right? So those tend to work in concert to minimize the probability or possibility that you're going to drive a car and achieve undesired outcome, which is failing to reach your destination because you were in a serious accident. But all of these risk management frameworks should be taken in the context of aligning risk with reward. So as human beings, we may be more inclined to engage in riskier behavior because we think that the reward at the end of that behavior is sufficiently great. For example, I might attempt to climb Mount Everest, right? An activity that has a very high mortality rate, high failure rate, is very expensive, but I think it's worth it to me because the sense of achievement from reaching the summit of Mount Everest, the memories, the photographs I can take, the fame, the social media lift that it creates makes me decide that it's worth doing that, right? Now, that doesn't mean that you don't ascend Mount Everest without taking the appropriate precaution. You train, you buy the right equipment, you use an experienced Sherpa as your guide at the mountain, and so forth. And so it's important to understand that risk management does not necessarily mean the elimination of risk or even minimizing, because there can become a certain point at which reducing risk further simply becomes prohibitively expensive. Now, why do we manage risk at all? Well, we manage risk because it's one of the most powerful and easy levers we can manipulate in order to manage, presumably increase value. Okay. And if you consider this fundamental value equation, otherwise known as a Gordon growth model or a perpetuity model, value is a function of how much cash flow you have, the rate and the rate at which it grows, and the expected rate of return on that investment. And that's a function of risk. The higher the risk, the higher the rate of return you require. That's why venture capitalists require a 40% rate of return on their investments, whereas somebody who is investing in an index fund, an S&P index fund, is looking at an 8% rate of return. Okay. So understanding basic math, whenever you have a fractional relationship such as this one, by moving K up or down, you move V up and down significantly. Now, I'm a big fan of risk management because I don't think that it's paid enough attention to. Nobody gets on Bloomberg radio or Bloomberg TV. Nobody's featured on CNBC or Fox Business News or Fox Financial because you're such a great risk manager, unless you're a hedge fund manager, I guess that's a separate discussion. So it's not sexy. It's often unappreciated, but it's often the easiest, the cheapest, and most impactful thing you can do to manage the risk of whatever asset we're talking about, whether it's a company or whether it is, in our case, intellectual property. And I put together a small numerical example, right? In this particular example, you can see that by simply lowering the required rate of return by 2 percentage points, right, we produce a 15% increase of value. And that's illustrative of the multiplier effect that risk management creates and why it's so powerful in business, why it's so important to understand how risk management works and to make that a tool in your arsenal. But even if you don't believe me, I'd at least ask you to believe a big four. I published a study a few years ago that suggested that companies with a specific risk management framework with respect to intellectual property were 40% more likely to avoid litigation. And we're going to go over litigation a little bit later in this webinar, but all of you know that litigation is at a minimum time consuming. It's usually terribly expensive. And sometimes in court, things don't go your way, even when they should go your way. And so any opportunity to lower risk of litigation, that's going to increase the value of the underlying intellectual property asset. Now, why are patents specifically so risky? And this is one of these places where patents diverge from other intellectual property. First, because of the American Invents Act that was passed last decade, they established the Patent Trial and Appeal Board, which basically allows the U.S. government to revoke a patent, either in part or in full, that they had previously issued. I can tell you that it's very much a hot button among inventors with U.S. patents. They find it angering, discouraging. Someone even said it's unconstitutional. I'm not going to cover that here. I can only tell you what it is. And the fact of the matter is, although PTAB being invoked in a given patent is fairly rare, they only do it a few times a year. When they do it, 82% of the time, at least one of the claims of the patent or patent portfolio is going to be invalidated. So PTAB getting involved in your patent is almost always bad news. Second, patents provide a target for predatory actors. Simple fact of the matter is that big companies squash little companies all the time through practices that we would consider unethical, that we would consider borderline illegal, certainly unfair. But at this time, the U.S. government has not seen fit to devote a tremendous amount of resources to preventing that. And so, unfortunately, there are many patents that simply wind up being effectively abandoned or ceded to a big actor because, and I'm not going to name a specific company because that's not fair to them, but because big company X says, we can easily spend $1 billion in this litigation. How much can you spend? And you said, I've got about $500,000 saved. And they say, we'll see you in court, and they'll just bleed you dry and take the patent. So you're better off managing that risk up front. And patents provide a lot of useful information to the competition. In the course of my life, I've been a big Apple fan, not as much as I have anymore, not for any reason, but you can see on YouTube, there's a whole bunch of analysis that's done by YouTube influencers that are attempting to predict the new products that Apple's going to release before they do. And one of the things that they do is they will analyze recent Apple patent filings to get an understanding of where Apple's technology strategy is headed. So that's a very real consideration when issuing a patent. Even if PTAB is not out there, even if you have the resources and wherewithal to fully defend it, the mere act of patenting creates conduit of information to the market, including your competitors, that you may or may not want. So why are patents so vulnerable? Why is there that 82% hit rate? The simple fact of the matter is that a patent examiner spends on average about 19 hours reviewing a patent before approving it. And given how complex technology is, oh, that's not enough time. And it's not for negligence. There just aren't enough patent examiners to go around with all the patenting activity. So one of the risk management techniques that I'm going to share with you today is that you should take on as much of the examiner's responsibility as you possibly can. Get out in front of it. So I meant to put the slide earlier. I'm not sure what happened, but I'm not going to skip it. I do want to come back to this because I think this illustration is really important. So risk management, as I said, is this concept of smoothing out big variability in outcome. Okay. So the goal is to go from the left to the right, where your roller coaster isn't quite as up and down. Now, some people equate risk management with risk elimination. And while that can be the case, rarely, really not practical in most cases, going back to the car analogy, cars could be made safer, I'm sure, somehow. If we were willing to pay $150,000 for a starter car, other features could be computers that take over driving when they sense a potential collision, or something that automatically recognizes a stop sign and hit the brakes for you. I'm just making things up. I'm not a car expert. But putting that technology in every car would make them prohibitively expensive. Or as Cordelia says, yes, a DUI tester to start the car, which does actually happen, but only with people that have been convicted of a DUI in some states. But that could become a standard of a car, but it would be quite expensive. Okay. So it's important to understand that risk management and risk elimination are related, but they're very different things. And walking, not driving, is a very extreme. You don't want to get into a car accident, don't drive. Now, that even then, you could be hit by a car as a pedestrian. So even that doesn't eliminate risk of being in a car accident. You have to stay at home in your basement. It's also important to realize there's certain risks that we can manage and certain ones that we can't. As an owner of an IP portfolio, there are risks that we just have no control over. As Apple, they don't have control over what product Google comes out with, or Microsoft, or somebody else. They cannot manage that in a meaningful way. They can only manage government policy so much through lobbying. And even Apple has limited success doing that. I'm broadcasting this to you from the European Union, and very much against Apple's wishes, they had to get rid of the lightning cable for USB-C cables because they wanted to get rid of the e-waste that comes from lightning cable. And geopolitics gets in the way. There are a lot of companies that have been hurt by the Ukraine-Russia war. There's nothing any company can do about that. There are many U.S. companies that have had to leave the Russian market, have had to write off billions of dollars of assets, including intellectual property. And that's just not something that you can very easily manage, if at all. However, IP specific, or what we might call an idiosyncratic risk, those are things that we can manage. Okay. We can manage the potential for our patent being annulled, either through PTAB or through some other legal process. We can manage our exposure to litigation. We can manage the attractiveness of purchasing or licensing the technology that is covered by our. Now, risk management, I think, starts ideally with the process of obtaining the patent. And I think that starts with hiring the best legal counsel that you can afford. That may be, but isn't necessarily the most expensive. I know some fantastic IP attorneys who work with big law and capital letters. I know some fantastic IP attorneys who are sole practitioners. Okay. But really boils down to finding out who has the right skill set, the right training for you. And it's not necessarily about somebody who can get you a patent. Most attorneys I know tell me that it's not that hard to get a patent. What's hard is to get a patent that matters. If you narrow your claims enough, you can eventually get a patent. But if your claims are so narrow that they don't really mean anything, well, you've got a nice certificate on the wall and you spend thousands of dollars to get it, but what does that really know? In addition to hiring the best legal counsel that you can afford, engage in a very thorough prior art search. Now, some attorneys I know include a thorough prior art search as part of their patenting process. Others don't. Others say, if we had to do that in addition to the patent, it would simply be cost prohibitive. So it's on a good faith efforts basis. And I appreciate that view. And I don't think those attorneys are doing anything wrong by any stretch. Certainly the ones I know are transparent about it. I think that you should pay up and task somebody who knows what they're doing. Could be somebody who's got patent examination experience, could be somebody who has patent counsel, could be somebody else who is experienced in the area, but task them with figuring out why you shouldn't be able to patent your technology. Because although it's a bummer to find out that you can't patent what you'd like to patent, you're much better off finding it early than late, after you've invested in millions of dollars in it, after you've built a business around it, after you've made significant financial and other commitments around that intellectual property. And get out in front of it, because if it goes to litigation, or whether it's the PTAB or in court, that search is going to be done. That search is going to be done by your opposing party, their opposing counsel, and the opposing expert. I also think that getting a second opinion on your patent application is a good idea. And your patent attorney probably won't love the idea. Nobody likes being second guessed, especially proud professional. I don't love being second guessed. But the simple fact of the matter is, again, we're talking about risk management here, and you want to make sure that your patent is as strong as it possibly can be. A second set of eyes can be very helpful. And that may include the patent itself, or are there areas where the language could be tightened up? Are there opportunities for additional claims that have been missed? Are there other considerations in a prior art search that should have been addressed or should have been found and simply weren't? Was the landscape analysis, in other words, the analysis of all intellectual property, not just patents and products in the marketplace, was that done as well and as thoroughly as humanly possible? And I just think it's very hard for even the best, most competent one individual to do all of those things flawlessly all the time. I think that's what I'm getting at, because I want to be very clear. I'm not suggesting at all that patent attorneys are hacks. They don't know what they're doing, and you just got to get somebody looking over the shoulder. Far from it. I think it's important to acknowledge that what you're asking them to do is incredibly difficult and is incredibly far-ranging and requires tremendous attention to detail. And so I think you owe it to yourself, in spite of the fact that it may create a little bit of tension with your patent counsel. I think you owe it to yourself to have somebody else go behind and make sure nothing is missed. And maybe nothing was missed, which is great. But if a few things weren't missed, you don't then turn around and fire your first patent counsel. What you do is you integrate that into the intellectual property to make it as, if not bulletproof, at least as bullet resistant as you possibly can. And to that end, I think when you hire legal counsel for intellectual property, especially patents, I think that industry expertise really matters. And again, don't take my word for it. Harvard Business Review says that in-house patent attorneys are 25% more effective than ones who are outside. And that it's not because they're smarter, but it's because in-house counsel has become an expert on the inventor's technology. They become an expert on the inventor's market. They get to draw upon massive amounts of institutional knowledge that informs their advice and informs their patenting process. So I don't want to turn this into a course about how to choose patent counsel, but I do think one of those dimensions should be to ask questions about what work have they done in a space that is similar, if not identical, to yours. Because in addition to just generally how hard the patenting process is, it's even harder if you have to study and learn about the industry at the same time. Now, I think it's also important with IP, especially patents, but it applies more broadly, to take a portfolio approach. Because what portfolios do is that you both reduce risk and you increase return at the same time through diversification. This is something we've understood in the stock market really since the 1950s. And that concept wound up winning the Nobel Prize in economics. And constructed properly, you can even add riskier intellectual property, but lower the overall risk of your portfolio as long as the intellectual properties are not correlated with one another. I mean, that they don't tend to move up and down in terms of value or in terms of utility in the same direction at the same time. So in the stock market, some of us might have high-flying technology stocks. At the same time, you might have power generation stocks, right? And you might actually increase the overall return of the portfolio by reducing risk because the utility stocks will never go anywhere. And the upside comes from the technology stuff. Now, critical thing to understand about patents is their life packaging. And I think other IP works this way too. I think you can say the same thing about copyrights in particular, and sometimes software. But patents are strongest, or what attorneys will call, or insiders, patent families, meaning that they're all protecting various elements and dimensions of the technology, but from different approaches in different ways. And so one of the reasons I don't do a lot of work with individual inventors anymore is because they typically have one patent. And one patent is really hard to monetize because a patent can only cover so much. And you can't ask patents to do too much, but a family of patents, in effect, protects each other. They create a greater footprint in the intellectual properties. So I have a question. Is working at patent in Eurozone and China too? Can be. Wait till the end of the webinar because I am going to get to that. Okay. So patents form mutual defense. They form mutual defense in a lot of ways. But one of the most important ways in which they provide mutual defense is if you have all your eggs in one patent and then that patent somehow gets attacked, invalidated through court PTAB, something else, you're just sunk, right? Patent gone, game over, no longer own intellectual property. But if you have a family of patents, let's say one patent is somehow invalidated or weakened. In this case, you still have 7 other patents that are active and you still gain a lot of the benefit of the intellectual property space. Now, could somebody go and litigate every single one of the patents? Sure, they could, but history shows that it's very unlikely that all of them are going to be invalidated, materially weakened at the same time. I think it's also important for companies, for inventors and IP owners to use what I call the buddy system. And what I mean by that is, I think finding a larger, deep-pocketed partner that has a vested interest in making sure that the intellectual property that you own remains yours, I think is very effective. So again, don't want to mention any names, but let's start with some big Silicon Valley company. And I've got a piece of software, and software is patentable, by the way. A lot of people think it's not, but it is. It's a little bit harder, but it is. So get a patent attorney who knows how to do software. And I just wrote that code with some buddies. We got like a 3-person firm. Maybe we raise $500,000 to get the firm going. At any time, one of the big companies could come by, sue us out of existence, or they could petition the U.S. government to invoke PTAB and attempt to institute our patent. Institute means put it up for review. basis objective to in a form of trial. And they know they're going to win because they know that I'm going to run out of money before this thing even gets to trial or before it completes the trial. On the other hand, if I'm partnered up with another big tech company and the big tech company is dependent upon this technology, this invention that's patented, and they're going to come in and help me fight this, then the first big tech company is going to think twice, three times, a long time before they decide they're going to pick that fight because they know that they're going to get a punch back. Even if you have to give up something, you may have to give up royalties, a bigger royalty deal than you want. I do think that exploring, finding partners that can help deter predatory actors can go a long way towards reducing the risk of your IP portfolio. It's also important to integrate a patent. If a patent just sits out there and it's not integrated into a business, it's much more vulnerable because if the patent for whatever reason is invalidated, annulled, we can, again, like I said before, game over. But if it's a component of a larger economic vehicle, then you still have the economic vehicle. Maybe you don't have the monopoly that you hoped you have, but you still do have the economic vehicle that can generate financial energy that you've been doing. And I liken it to of a spark plug. The price of a spark plug is what, $8, $9, something like, I don't know, I haven't replaced spark plug in a long time, but last time I bought it, I think it was like $5 and so with inflation, I'm going to call it $9 or $10. That spark plug on the shelf in an auto parts store is really worth $10. But if that spark plug is contributing to making your car go, you could argue that spark plug is worth $20,000 because without the spark plug, your car doesn't go anywhere. And your $20,000 asset is rendered inert. It's a reverse example, but it still works. By integrating your intellectual property into a business, monetizing it, it actually helps protect the value that you're gaining from the patent, if not the patent itself. In a business context, we'll think about this in terms of the value of the whole, but the patents work alongside management, capitalization of the company, strategy, possibly other things that we can think of, right? But just as we wouldn't take management out of the company and try to solve it, we can't really separate the strategy. Those things are not nearly as valuable as they are when they're part of the overall economic engine. And patents work, I think, in precisely the same way. And it's that interdependency that creates strength. I put this picture of a honeycomb because it turns out nature has created one of the strongest geometries ever. The honeycomb, the hexagon, is actually one of the most efficient ways of organizing building material to create the most amount of strength with the least amount of weight. Many aircraft wings actually have honeycomb structures inside because you get 90% of the strength, but only 30% of the weight. So it increases the performance of the airplane. And it's because the geometry of the cells of the honeycomb are such they create this mutual strengthening energy. And so that's what patents do as well. Why do investors, plus institutional investors like banks, interested in IP collateral funding, insist on I assume a broad patent, pending application, or some at least require a granted patent? So you're touching on something I may do at a later date, which really gets into what value do patents have aside from the monopoly that they give you. I think the biggest reason they want this is it's a signaling effect, because many, not all, maybe not even most, but many investors are like me, not that I'm an investor, but they're like me in that I have a finance and economics background. I'm not an engineer. I'm not a scientist. The last science class I took was geology as a sophomore in college a million years ago. In fact, the new geology classes are probably studying the paintings I made in the cave. I took that last class, okay? And so They rely on the signaling effect of the patent office to say that the underlying technology is somehow novel, unique, useful. Okay. I think that's a big part of it. I think also broad patent pending application. I think it's because they don't know how to properly, I don't think they always know how to properly perform due diligence on the patent. You can have very broad patents that are so broad that they're going to be easily challenged in court and nullified. Because of the nature of the patent, and in keeping with this theme, I think another way of managing risk in your intellectual property portfolio should go well beyond your patent counsel. Every patent counsel I know would agree with me on this. They want to work in a team that includes marketing, that understands the market landscape. They want the actual engineers to have a seat at the table. They want the finance people in the room to understand the business case, the financial business thesis of the intellectual property. Writing shotgun alongside legal, because those perspectives better inform legal counsel as to how they should go about prosecuting a patent. Prosecuting means obtaining the patent. That's not the litigation piece. As well as how you should go about protecting the patent or patent portfolio in the most effective way possible. Now, often overlooked facet of intellectual property risk management is simply documenting policies and procedures. And these procedures can include what's on the screen. I'm not going to read the slides to you. But again, this is one of these deals. Don't believe me. Go ahead and believe the companies that have a formalized policy, a formalized training around patenting actually are more successful, 20% more successful in creating patentable invention, right? That's a big deal. You also need to monitor. You need to keep an eye on what's going on out there in the marketplace. You have to know when somebody's infringing on your patent. You need to identify that and act early. If you act early where the infringer hasn't made a massive investment in the patent yet, then you may be able to get the desired result, cease and desist letter. If, on the other hand, you raise the patent infringement 3 years after the fact and they've raised or invested $50 million into it, as a matter of defending their livelihood, they're going to go down with this. They're going to die fighting. They're going to fight you tooth and nail until a jury verdict, and they're going to fight you through as many appeals as is required until they get the result that they want from the Supreme Court, or you're just simply tiring of the litigation. And another big four said that companies that are actively monitoring their competitors' patents are more likely to achieve above average profitability. Now, I think there's an element to that as well. That's simply monitoring patents to understand their strategy. I think that contributes to profitability. We talked about that earlier. And maybe there's a causality that goes in the other direction too. Maybe companies that are better managed, better run, are more likely to be diligent enough to be monitoring their competitors' intellectual property. I'm not sure. I think reasonable people can be on both sides of the argument. But I do think the statistic is interesting, if not compelling. This sounds like a no-brainer, but it's not, so bear with me. There can be a lot of traps in drafting and reviewing what seem like fairly mundane contracts. And a friend of mine who's been through this process actually shared some documents with me that inform me. So I'm actually talking through the secondhand experience here. Many confidentiality agreements, you need to have non-circumvention agreements and non-competition agreements in place, or at least as clauses of the non-disclosure agreement that commit the entity to which you are disclosing the proprietary information that they are not going to take that information and compete with you in some fashion. And to ensure, especially if it is up and patented, that it doesn't wind up being an accidental disclosure. Because once you disclose, it's very hard to undisclose. You cannot unring the bell, at least not very easily. Something else to keep in mind, sometimes scope of work agreements and purchase orders can be very sneaky. that there'll be fine print in those agreements. That is what my friend shared with me. They'll have fine prints in the agreement saying that when you build this machine for us, or when you make this product for us, we own the intellectual property, which is right. But this is why you pay your lawyers the big bucks, is to find that stuff and identify it so that you can push back, or at least say, look, I'm not signing this. It doesn't speak well of the company that's trying to get you to sign it. No, but, and you can decide whether you want to continue the conversation, but there are ample opportunities in what appear to be fairly mundane contracts to accidentally surrender your intellectual property, right? So this is an important risk management approach. So here's some verbiage that, again, my friend lifted from some of his agreements that he agreed to allow me to share. And you may want to take a screenshot of this. Make sure you have language like this inside your non-disclosure agreements. Run it by an attorney. I cannot emphasize this enough. I'm not an attorney. I'm not smart enough to be an attorney. I've never been educated in the law whatsoever. I'm just presenting this out here as something that is a resource, but make sure that somebody who's actually an attorney reviews the language before you bet your company on it. And here's more of the same. I'll give you a second to take a screenshot of this, and we're going to make this available as a recording. So the purchase order gotcha, the one really struck me, that a fairly innocent document. And of course, you're all excited. Who's excited to make a sale? Well, in this particular case, my friend, when he makes a sale, he sells $200,000 at a time. So it's a big deal. But because of his detail-oriented nature, he's an engineer by training, he read every last word of that contract and found the language that said that by signing this purchase order, you're agreeing that once you build this machine for us, that we then own the intellectual property. Certainly called him on it. That he did wind up making the sale, but he had that language taken out of the agreement. The fact of the matter is that owning intellectual property is expensive if you want to keep it. And one of my laws of intellectual property, if you have intellectual property, it's a guarantee that somebody at some point is going to try to steal it. If you don't have the money now to defend your patent or defend your intellectual property, start socking money away for that rainy day fund, or make arrangements so that you have financing available. Don't be that inventor, don't be that company that can be steamrolled simply because you have a smaller bank account than they do. It stinks that the legal system works that way, but it does work that way. And we have to operate in the real world here. You may be able to obtain insurance for your intellectual property. And there are two kinds of insurance. You can often buy them together, but you may buy them separately. You can buy separate policies for infringement as well as enforcement. Infringement means if you're sued for infringing on somebody else's IP, enforcement is, of course, enforcing your intellectual property when somebody else is infringing. Okay? And here are some companies that I know, at least I understand, are actively involved in this market. There are probably others, but I'm not going to put a million logos on here, but this is at least a place to start. It's not going to be cheap. And I think a minimum amount you're going to pay is $5,000 a year. That's going to be for one patent with a relatively narrow scope of claims. Depending on the nature of your patents, you could easily have 6 figures of insurance, but it may be worth it to avoid the potential of being faced with a $5 million legal bill and not being able to pay it. Now, some of you are probably thinking, what about litigation finance? And for those of you who aren't aware, there are providers of finance who, in exchange for a cut of the winnings from your patent litigation, will agree to pay for that litigation. You could do a separate webinar about that, but it falls outside of the scope here. But I think the big thing to keep in mind is that litigation finance companies are like venture capitalists. They are presented with many opportunities, more opportunities than they can or even should finance. Okay? So here are some companies out there that actually do it. And based on their public disclosures, as you can see, that the highest acceptance rate of cases is 10%. It's out there. And if you can get it, it may very well work for you. And it would be a good idea to at least start developing relationships long before you need litigation finance with people in those companies. So that when and if you do need that finance, you've got some sort of relationship that gives you a warm entry into the company and raises your likelihood of receiving the backing you need to protect your intellectual property. Now, you may also want to consider expatriating your intellectual property because in other markets, in particular Europe, I can speak to Europe more intelligently than, say, Asia. But Europe doesn't have a PTAB. They don't have the second bite of the apple. And generally speaking, litigation is far less expensive. With the exception of Great Britain, Europe is a far less litigious place than is the United States. Many companies don't have jury trials, and they would not put a matter like a patent matter in front of a jury anyway. They would presume that judges are better intellectually equipped to adjudicate cases like that. And such cases tend to go much more quickly, and they're far less expensive. Of course, the downside is it's one thing to patent in Europe, it's another thing to pursue the market in Europe. But it is a type of risk management so that if for whatever reason your patent is somehow nullified in the United States, you do still have monopolies in other markets that you can exploit should you choose to do so. You retain the option of doing so. It's not going to make sense in every case, but in some cases it very well might. All right, so as we wrap up here, I'm giving you a to-do list. Consider what we talked about today in the context of that strategy and see what you can use, see what you can apply from the last hour to make your patent risk management strategy more robust and more reliable. Oh, and if you don't have a patent risk management strategy, then start one. This is a good place to begin. In the 80-20 rule, there are other things which you can add to it in your unique circumstances. But this at least is a good outline for you to start one. And if you have any questions, whether it's about making your management strategy more robust or starting one from scratch, please reach out to me, set an appointment, let's have a conversation. If I can't help you, there's a good chance that I know you can. So I'd love to thank all of you for me today.